5, 4, 3, 2, 1, start. As per the pleaded case of the plaintiff respondent, he was appointed as a constable with the police force on 12 June 1995 full stop. He had a good service record, but he was dismissed from service by order dated 4 February 1990 full stop. It has been averred that before dismissal, no regular departmental inquiry was held, nor was the plaintiff given any opportunity to defend himself full stop. It has been pleaded that the plaintiff was named as an accused in FIR number 19 dated 19 January 1990 lodged at police station GRPS Amritsar under section 120B and 409 IPC and section 1 and 4 of terrorist and disruptive activities (Prevention Act 1987), and the dismissal order is based on the registration of the FIR full stop. After the plaintiff respondent was acquitted by the trial court on 16/11/1991, he filed an appeal before the IGP Railways, which was dismissed on 26 March 1992 full stop stanza. Challenging both the orders, he filed a suit for declaration that both the said orders are illegal, malefied, arbitrary, etc. and violative of the Punjab Police Rules 1934 as well as the Constitution of India full stop. Plaintiff also sought a declaration to the effect that he continues to be a constable and is entitled to all the pay, privileges, etc. full stop. Upon notice, suit was contested by the defendant's appellants by filing a written statement wherein various objections were taken full stop. On merits, it was submitted that the plaintiff respondent did not have a clean past and was given a written warning when he was caught taking illegal gratification in the year 1989 full stop stanza. It has been further submitted that on 18 January 1990 a special track patrol party was sent on Amritsar Bias section at 8 p.m. which consisted of 7 members including the plaintiff respondent full stop. 1 LMG rifle with 9 magazines filled with 200 cartridges was issued to Constable Surjit Singh and he was deputed a helper full stop. The other members on the patrolling duty were issued 1 303 bore rifle of 50 cartridges each and Constable Sarabjit Singh was issued 46 cartridges full stop. After completing its round, when patrol party reached back at Amritsar, they reported loss of 1 LMG with 8 magazines filled with 200 cartridges and 1 303 bore rifle with 5 cartridges full stop. It was stated that the arms were handed over to terrorists and the plaintiff respondent along with Constable Palvinder Singh were the mastermind full stop stanza. Acquittal of the plaintiff in the criminal trial was admitted and it was submitted that the star prosecution witness did not support the version of the prosecution full stop. It was further submitted that the activities of the plaintiff respondent were a threat to public peace and order and that the plaintiff respondent had hatched a conspiracy of handing over of arms and ammunition to the extremists full stop. It was further submitted that the impugned order has been rightly passed and the provisions of Rule 16.37 of the Punjab Police Rules are not attracted full stop. Plaintiff filed replication and reasserted the allegations levelled in the plaint full stop. On the basis of the pleadings of parties, issues were framed and after the parties led evidence, trial court by judgment dated 1/11/1993 decreed the suit and declared both the impugned orders as illegal and void while holding that plaintiff respondent is entitled to all the consequential benefits, full stop, stanza. Appeal preferred by the defendant's state was dismissed by the First Appellate Court by judgment dated 11/5/1996, full stop. In this backdrop, defendants state are before this court in the present second appeal, full stop. State counsel has argued that dismissal order was passed in exercise of power under Article 311 within bracket 2 of the Constitution of India, as it was not reasonably practicable to hold a regular departmental inquiry because plaintiff respondent was mixed with terrorists and had handed over arms and ammunition to them, full stop. He asserts that reasons for dispensing with the inquiry had been recorded separately, but the trial court decreed the suit, holding that the reasons had not been brought on record, full stop, stanza. He submits that an application for leading additional evidence was filed before the lower appellate court, but the same was rejected while dismissing the appeal of the appellants, full stop. It is his argument that the lower appellate court has erred in rejecting the application and in considering a very material document, full stop. On the other hand, counsel for respondent plaintiff has supported the orders passed by the courts below and has urged that there was no material with the authority to come to the conclusion that it was not possible a hold a departmental inquiry, and as the plaintiff respondent had been tried on the same charges by the criminal court and had been acquitted, his services could not be dispensed with without holding a regular inquiry, full stop, stanza. I have considered the submissions made by counsel for the parties and have examined the record with their able assistance, full stop. While dismissing the application for additional evidence filed by the defendants state, the lower appellate court has held that the application does not specify the contents of the note sought to be produced, full stop. The court further was of the view that there is nothing to show that the evidence was not to the knowledge of the appellants, and even after exercise of due diligence it could not be produced by them before the trial court, full stop. The court was of the opinion that as this evidence was never sought to be produced before the trial court, the application was not maintainable, full stop, stanza. Still further, the lower appellate court was of the view that there was a delay in the presentation of the application in as much as it had been preferred in September 1994, whereas the appeal had been preferred in February 1994, full stop. In the opinion of this court, the lower appellate court has misdirected itself while declining the application, and the order rejecting the application and the dismissal of the first appeal cannot be sustained for the reasons discussed in the succeeding paragraphs, full stop. The reasoning given by the lower appellate court for rejecting the application is highly technical, full stop, stanza. It is not the requirement of Order 41, Rule 27 CPC that the additional evidence sought to be produced should be reproduced in the application, full stop. The note recording the reasons for dispensing with the inquiry which the state appellants intended to bring on the record by way of additional evidence was appended with the application and should have been looked into to appreciate its importance, full stop. An examination of the note dated 3 February 1990 shows that the punishing authority has given detailed reasons for coming to the conclusion that it was not reasonably possible or practical to hold an inquiry, full stop. The authority was of the view that as the plaintiff respondent and his colleagues had acted in connivance while delivering arms to an extremist, none of these persons were likely to come forward to depose in the departmental inquiry, full stop, stanza. It has been found that the plaintiff respondent was planning to join the extremist group was in contact with extremists and the militants to whom the arms were to be supplied had not been arrested, and even if they were apprehended, they were not likely to depose against him. Full stop. In these circumstances, satisfaction has been recorded that it was not reasonably practical to hold a departmental inquiry against plaintiff respondent, and by exercising power under Article 311 within bracket 2 of the Constitution, plaintiff respondent is being dismissed from service by a separate order. Full stop.